Supreme Court of India Lalu Yadav versus the State of Uttar Pradesh and others decided on October 16, 2024 INSC 782 facts of the case. FIR was registered under sections 376 and 313 of IPC against the petitioner. High Court dismissed the petition under section 482 crpc. Findings of the court. We have already taken note of the facts revealed from the subject FIR itself that the time of occurrence of offense is allegedly from January 5, 2013 to January 5, 2018, and that it was registered only at 21.34 hours on February 21, 2018. That apart, it is evident that even going by respondent number 4, the complainant herself and the appellant were living as husband and wife. The complaint of respondent number 4, as is revealed therefrom, is that the appellant had deceived her by promising to marry, and then by establishing physical relationship. At the very outset, it is to be noted that there is a huge irregularity between the statements established physical relationship with me without my consent and started living with me as the husband. Be that as it may, bearing in mind the allegations raised by respondent number 4 reflected in the subject FIR, we will refer to the relevant decisions of this court. We are of the considered view that the High Court has palpably gone wrong in not considering the question whether the allegations in the complaint reveals prima facie case that the complainant had given her consent for the sexual relationship with the appellant under misconception of fact, as alleged, or whether it reveals a case of consensual sex. Firstly, it is to be noted that the subject FIR itself would reveal that there occurred a delay of more than 5 years for registering the FIR. Secondly, the very case of the complainant, as revealed from the FIR, would go to show that they lived for a long period as man and wife. And thirdly, the facts and circumstances obtained from the subject FIR and other materials on record would reveal absence of a prima facie case that the complainant, respondent number 4, had given her consent for sexual relationship with the appellant under misconception of fact. At any rate, the allegations in the FIR would not constitute a prima facie case of false promise to marry from the inception with a view to establish sexual relationship, and instead they would reveal a prima facie case of long consensual physical relationship during which the complainant addressed the appellant as her husband. Moreover, it is also the case of the complainant, revealed from the subject FIR and the other materials on record, that she went along with the appellant to Varanasi with the knowledge of her family and stayed with him in hotels during such visits. The subsequent refusal to marry the complainant would not be sufficient, in view of the facts and circumstances obtained in the case at hand, by any stretch of imagination to draw existence of a prima facie case that the complainant had given consent for the sexual relationship with the appellant under misconception of fact, so as to accuse the appellant guilty of having committed rape within the meaning of section 375 IPC. Now that the allegation of offense under section 313 IPC is omitted, there is absolutely no prima facie case for proceeding further against the appellant on the allegation of commission of offense punishable under section 376 IPC. We are of the considered view that the High Court should have exercised its inherent power. FIR and all further proceedings on its basis are quashed. The appeal is accordingly allowed.